Alright. So today we are going, or on this video, we are going to discuss Article 1523. So, where in pursuance of a contract of sale, the seller is authorized or required to send the goods to the buyer. Delivery of the goods to a carrier, whether named by the buyer or not, for the purpose of transmission to the buyer is deemed to be a delivery of the goods to the buyer, except that in the cases provided for in Article 1503, first, second, and third paragraphs, or unless a contrary intent appears. Unless otherwise authorized by the buyer, the seller must make such contract with the carrier on behalf of the buyer as may be reasonable, having regard to the nature of the goods and the other circumstances of the case. If the seller omits so to do, and the goods are lost or damaged in course of transit, the buyer may decline to treat the delivery to the carrier as a delivery to himself, or may hold the seller responsible in damages. Unless otherwise agreed, where the goods are sent by the seller to the buyer under circumstances in which the seller knows or ought to know that it is usual to insure, the seller must give such notice to the buyer as may enable him to insure them during their transit, and if the seller fails to do so, the goods shall be deemed to be at his risk during such transit. Alright, so I've just read the article itself, so let's proceed with the explanation. So I assume that most of my viewers who are student are uh, capable, or they have access to the book, either PDF or the actual book of law on sales. So let's proceed with the explanation. So delivery to carrier on behalf of buyer. So it says here that the general rule where the seller is authorized or required to send the goods to the buyer, according to Article 1521, Paragraph 1, the general rule is that delivery of such goods to the carrier constitutes delivery to the buyer. Whether the carrier is named by the buyer or not, in such case the delivery of goods on board the carrying vessel partakes the nature of actual delivery, since from that time the buyer assumes the risk of loss of the goods. So to explain this explanation na nakalagay sa book, so dito sa general rule, si seller obviously one of his obligation is to deliver the things sold kay buyer. Kapag yung delivery of goods ay through a carrier, this means that it is delivery to the buyer. Kahit na hindi sinabi ni buyer yung what particular name of carrier. Kapag yung goods daw ay nakakarga na sa vessel or nakaload na and for delivery na ito, which is actual delivery, from that time daw, si buyer na yung magsho-shoulder ng risk of loss of the goods. Alright, so let's proceed to the second. So here we discuss exceptions. So exceptions, they are those provided for in paragraphs 1, 2, and 3 of Article 1503. The seller retains ownership and even if the goods were already at the disposal of the buyer until the buyer did the exact fulfillment. Second, the seller is the consignor and is the consignee or receiver as well, retaining the ownership over the goods. Number 3, the goods are deliverable to the buyer but the bill of lading remains to the seller. Seller retains ownership over the goods. So, all three paragraphs from Article 1503 refers to seller retaining the ownership over the goods. So there's a contrary in turn appears to the exception provided for Article 1503. And ito yung mga the parties did not intend the delivery of the goods to the buyer through a carrier. Second, the seller is not responsible for misdelivery by carrier. Third, the carrier was chosen and authorized by the buyer to make delivery. Now, to elaborate this even further and for you to understand, let me simplify this, okay? May pinrovide kasi ng mga exceptions sa Article 1503 and ang basic concept nun is si seller, inire-retain niya yung ownership kahit delivered na kay buyer yung goods for the seller to have the security na si buyer ay i-perform yung obligation niya. So what's the obligation? Yung pagbabayad ng purchase price. Kaso kapag meron daw contrary intent or an opposition or opposite dun sa agreement na yon, nag-agree yung parties na hindi i-deliver kay buyer yung goods sa pamamagitan ng carrier. Kapag daw ganon, hindi na responsible si seller for misdelivery since hindi naman na niya retained yung ownership over the things sold. And since yung carrier naman at the first place, si buyer, yung pumili para i-deliver sa kanya yon, so si buyer yung magiging liable for risk of loss during the delivery. So let's proceed to seller's duty after delivery to carrier. So the fact that the ownership in the goods may have passed to the buyer does not mean that the seller has already fulfilled his duty to the buyer. So given the fact na sinabi ni seller kay buyer na i-deliver ko na yung goods mo, ha? This does not necessarily mean na tapos na yung obligation ni seller. Remember, even if the ownership ay naipasa na kay buyer as he is responsible for such na, always remember delivery equates to control and possession. So kahit pasabihin ni seller na na-load ko na sa carrier, so wala na akong obligation sa iyo. Hindi lang yun basta-basta ganon. So when we speak of delivery, we have to consider two things. One, possession and control. So, sino ba ang nasa possession if there's a carrier? Ang possession ay naki-carrier kasi nasa kanya yung goods on his disposal. And the control, we could say that it is also upon the carrier as he is the one who is keeping or being the custodian for the buyer. So, bottom line, wala pa rin kay buyer yung delivery. So, number 1, to enter on behalf of buyer into such contract reasonable under the circumstances. If the seller omits to do so, the buyer may decline to treat the delivery to the carrier as a delivery to himself in case the goods are lost or damaged in course of transit. Buyer may hold the seller responsible in damages. If the buyer exercises the first right, the transfer of ownership will be deemed not have taken place. So, explanation to this, ang unang duty daw ni seller is to deliver the goods to a carrier on behalf of the buyer. So, this means na dapat naka-address talaga yung delivery para kay buyer. Tsaka dapat under reasonable circumstances. Yung reasonable circumstances, ito yung mga dahilan kung bakit kailangan gumamit ng carrier to transport the goods and it's either malayo yung geographical gap between seller and buyer. Kapag si seller ay hindi nai-address or nai-address yung goods on behalf of buyer through delivery of carrier, 1, si buyer pwede niyang i-reject. The buyer may reject or decline or hindi tanggapin yung delivery to the carrier bilang delivery para sa kanya kung yung goods ay nawala or nasira habang i-deliver ito. Okay, so let's give an example. Halimbawa, nagkasundo si seller at si buyer na i-deliver yung goods to a shipping company since from China to Philippines. Sinabi rin ni buyer na dapat naka-address sa kanya yung goods na i-deliver. Kaso yun palang i-deliver ni seller na goods ay may extra for the reason na sige, isasabay ko na lang din to dito sa ibang items para isang deliveran na lang. And since ganun yung ginawa ni seller, instead na directly i-deliver yun kay buyer, dadaan pa pala yun sa isang sorting facility. So meaning nagsisinungaling si seller na naka-address kay buyer yung delivery. Kung sakaling mawala yung goods habang sakay-sakay ng ship at nalaman ni buyer na hindi pala directly addressed to him, although the seller notified him of the loss, si buyer pwede niya i-reject yon o di naman kaya ay pagbayarin si seller ng damages para sa inconvenience na nagawa nito sa business niya. The law does not make a carrier for all purposes the agent of the buyer, to whom the goods are consigned. The agency relates to the transmission of the merchandise only. Sinasabi lang dito na si carrier, hindi siya pwedeng maging agent ni buyer even though kay carrier naka-entrusted yung goods. The agency of the carrier ay para lang sa pagtransport ng goods. This means na distinct or no relation at all si carrier kila seller at buyer. So there will be no conflict of interest. So number two, to give to buyer regarding necessity to insure goods, the seller must notify the buyer for the buyer to be insured of the delivery to carrier under such circumstances. If the seller fails to do so, the seller will bear the risk of loss. As an exception to that ruling, if the seller failed to perform the notification to the buyer, but the buyer has access to information of whereabouts of the goods, making the buyer knowledgeable, seller is not liable for loss of goods. So, to explain this, dito may obligation din si seller na sabihan si buyer kung na-deliver ba sa carrier yung goods, or kung ano na yung status ng delivery, para may assurance si buyer na talagang i-deliver ni seller yung goods within fixed or reasonable time depending upon circumstances discussed from preceding articles. Kung si seller ay hindi sinabihan si buyer, si seller yung magso-shoulder ng risk of loss since wala ngang knowledge si buyer na on delivery na pala yung item. So basically, if he is not knowledgeable on delivery na, which constitutes that the ownership is transferred to the buyer, kaso hindi nga niya alam yon, si seller yung magso-shoulder ng risk of loss. However, there is an exception for seller being liable. Kung si seller ay hindi sinabihan si buyer na on delivery through carrier na yung goods, kaso may tracking number pala si buyer at pwede niya matrace yung status of delivery ng goods at alam niya na on delivery na ito through a carrier, this constitutes na from the time the buyer made aware of such, the ownership passes to the buyer, making him liable for which he will shoulder the risk of loss. So, ang perfect example na itong ganitong situation is yung online shopping. So, not to be biased, and this is not sponsored, as a perfect example is yung Shopee or Lazada. So, halimbawa, umorder ka ng Gucci bag sa Shopee from overseas worth 100 pesos. Let's say, obviously, baka di ka pa nga i-chat pa ni seller para lang maging aware ka na sa status of delivery. Since si Shopee ay merong pre-built na menu to know the status of your item. So, let's proceed to definition of shipping terms. So, number one, COD, collect on delivery. So, you might ask, is it similar to cash on delivery? Yes, it is very similar. Kaso ito, I guess it is more formal, or I don't know. Maybe they use this less. Mas naging familiar lang tayo sa cash on delivery. So, COD, collect on delivery. Carrier acts for the seller in collecting the purchase price. Buyer must pay for the goods before he can obtain possession. So, the explanation for COD or collect on delivery, again, perfect example nito is yung relationship ni seller, carrier, and buyer, commonly found in online shopping. Si carrier, pipick upin niya yung goods from seller, then si carrier, i-deliver niya yung goods kay buyer. So, since cash on delivery nga siya, at the time the goods have arrived to the doorstep ni buyer, dun pala magbabayad si buyer and will take possession of the item. Then si carrier, siya yung collector ng payment on behalf of the seller. So, number two, FOB or free on board. So, goods are to be delivered free of expense to the buyer. So dito, meron tayong two types of passing of ownership. One is free on delivery on shipping point and free on delivery destination. So dito sa FOB on shipping point, uh, once na nakaalis na yung ship o yung vessel sa docking port nito, the ownership passes to the buyer. And when we speak of FOB destination, once na i-deliver na once na na-deliver na yung goods sa specified location ni buyer, ownership passes to the buyer. So sa FOB destination, dapat nasa doorstep na ni buyer bago pa lang ma-transfer yung kanyang ownership over the goods. So CFI, cost, insurance, and freight signify that the price fix covers not only the cost of the goods but the expense of freight and insurance to be paid by seller until it arrives to the destination of the buyer. Ibig sabihin lang ng CFI, ito yung mga additional cost na binabayaran ni seller since merong mga shipping fee, 'di ba? Tapos yung insurance para to make sure na hindi basta-basta mawawala or in case na masira man, mako-cover yun ng insurance. So that the carrier will treat the goods properly. Yung cost na ito is until ma-deliver na kay buyer yung goods na sa mismong place niya. And that's it for Article 1523. And I hope you learned something from this video. And if you like this video, you can like this video. And if you wanna see more, please subscribe to my channel. And I'll keep on uploading some more. And thank you.